State of Tennessee versus Shatara, Evette Jones.
Ms. Coleman, good morning.
Good morning, Your Honors. Judge Holloway, is that good? Okay,
That looks like a yes.
perfect. All right, well, good morning,
Let,
Your Honors.
let me just mention, I'm sorry, I've got 3 computer screens up with the docket and the memos, and I have to go back from one with my mouse. So why it takes me a while to unmute. Sorry about that.
Not a problem. I understand. Well, good morning, Your Honors. My name is Erin Coleman. I have the honor of representing Shatara Jones on this matter as her appellate counsel. And so I would like to request 3 minutes for rebuttal if necessary.
3 minutes, yes, ma'am.
Thank you. In this case, the element of mens rea is arguably the most important element of a crime. The question of why a crime was committed and what the defendant was thinking or feeling must be answered by the state in every case. Under the Confrontation Clause of the United States Constitution, the defendant is allowed to confront the state's theory of mens rea and dispute it. Yet in this case, the defense was never allowed to fully make their argument disputing the mens rea to the jury. The state will argue that the court has full discretion to decide whether a statement is hearsay or not, or whether evidence is relevant, or even whether important evidence which was testified to being lost is a Ferguson violation. Yes, under the laws established in the state of Tennessee, the court does have such discretion. But what is the breadth of that discretion? And should that breadth be used with increased caution in a case in which the person is facing life in prison? I believe the answer to that question is yes. Here, the trial court continually used its broad discretion to hinder the ability the defendant had to prove her true mens rea to the jury of her peers. It took away the defendant's capability to defend herself to the fullest extent the law provided. And this was a violation of her constitutional rights, and thus the conviction should be overturned and she should be given a new trial.
Is this going to your argument about the statement that was allegedly made to the
Mr.
driver, her uncle?
Yes.
That I thought he was going to shoot me or something like that?
Yes, Your
Okay.
Honor. There are 3 of the arguments that I wanted to note in my oral argument, not the whole brief because you've read it and there's no need to repeat everything. But the 3 that I'll be focusing on are the court's motion or dismissal of the motion to suppress the cell phone records, or it was a motion to suppress the cell phone record based on the ill-gotten search warrant. The motion, the court's abuse of its discretion in not allowing in the excited utterance, or allowing trial counsel to really put forth the foundation to prove an excited utterance, and then finally the trial court's error in denying trial counsel's motion to dismiss due to the Ferguson violation. And just for your honors, just a quick housekeeping note, I was not trial counsel. I know my brief does state that. I just wanted you all to know that I was not trial counsel. I was appointed as trial counsel or as appellate counsel.
This actually started out in the posture of a post-conviction, didn't it?
It did.
And you were appointed on that.
I was appointed on that, and then Judge Smith decided to allow for a new trial motion to be heard in front of her due to original trial counsel's late filing of that new trial motion. She has then
So technically, this is a delayed appeal from a 2016 conviction.
Yes, Your Honor.
Okay, thank you.
to move on to those three arguments. These violations started, the abuse of discretion violations started with the motion to suppress the ill-gotten phone records. It is obvious from the search warrant, which was signed in June 14th of 2016. Sorry. That there was not valid, it was not, that the search warrant was not valid on its face or within the four corners of the document. There was no probable cause prior to the reviewing of the phone records as was to indicate that the phone was Miss Jones's phone. The state was never able to provide evidence found before the search warrant was gotten on June 14th that the phone in question belonged to Miss Jones. In fact, sorry, I'm getting ahead of myself. This proof of ownership is imperative to the legality of the search warrant. It was obvious from the trial record that Detective Gish did not know whose cell phone it was at the time that the extraction was made. The extraction was, my reading of the trial record is that the extraction was made on May 27th. Miss Jones didn't come forth to the MNPD officers to tell her side of the story until May 28th. Therefore, this extraction was done ahead of time and also done ahead of the search warrant itself being signed by...
Let me ask you before you go further down that road, do you agree that that issue was not raised in the motion for new trial?
I believe it was in our motion, in my motion. I would have to look back, I'm so sorry, but I believe that it was raised in the secondary motion for a new trial. I could be wrong, I'm so sorry, I didn't review my first motion before today.
So you filed a motion for new trial and then you amended it to add some other issues?
Yes, Your Honor.
Okay.
And I believe also, and if it was not filed in that motion for a new trial, it was filed as a motion to suppress during the trial procedure prior to trial. And that's where this motion to suppress was. It was filed by trial counselor Mr. Cate and was denied during the pre-trial procedure as well. It is obvious from trial, that poses the question of why the police were given the search warrant more than 2 weeks after the murder and after the phone data was actually extracted, to extract the data from the cell phone in the first place. This question was posed by trial counsel in his motion to suppress the evidence, and the state, in my mind, never gave an answer as to why to uphold the extraction within the laws of the United States and the Fourth Amendment. As noted in our brief, the detectives did not know Miss Jones' affiliation with the homicide until she came to the precinct on her own on May 28th, per the guidance of her pastor. And the extraction was obviously completed on May 27th, per the trial record. Thus, the trial court abused its discretion in denying this motion to suppress. Secondly, and possibly I would argue the most important issue in our brief, was the trial courts not allowing the excited utterance, or at least allowing trial counsel to fully set forth the stage of why the comment of "he was robbing me" was an excited utterance. And that because that comment was imperative to Miss Jones's defense, the defense of self-defense, which is an ultimate defense to a murder.
So what was the triggering event that caused her to say, "I thought he was trying to rob me"?
Sure.
What was the triggering event?
My understanding of the trial record is, and in reading of the evidence, is that Miss Jones came to the parking lot and to make a drug buy. She got out, Mr. Gentry came into the car through the window and pulled, I think, a piece of jewelry away from her, or maybe money, I can't remember, I'm so sorry, about the extent of what was taken from her. She got out of the car to chase him for that. And at that point, there is some indication that guns were pulled and she shot first in order to defend herself, and then came immediately back to the car and said he was trying to rob me to Mr. Chandler.
What evidence is there that he, the victim, pulled a gun?
I believe, and this goes into the last argument, that Miss Tipton, who was an eyewitness, was able to see what was happening. Now the court, we'll get to that if we have time. The court stated that the video surveillance of the area was good enough to negate the need for Miss Tipton's recorded interview with the detectives. But as we know, video surveillance is only pointed in one direction. And so Miss Tipton apparently had a different, was placed in a different area of the apartment complex and had a different view than what the video surveillance was able to provide.
So we haven't had the benefit yet of seeing the video surveillance. What will that show us?
I believe that it does show the young man with a gray hoodie and them approaching each other in the parking lot, and then you do see the shot fired.
3 shots,
Three
at
shots.
least.
Yes. Yes, but you see, I believe you see the murder, but I don't believe that you can see from the vantage point of the video his gun that was involved. And we.
And was a gun ever recovered?
So the police were not the first on the scene. Neighbors and family members were. And so it is my understanding that a gun was taken and it was never recovered off of Mr. Gentry, but there is also a very good time period in which neighbors and family members were able to, allegedly were able to deal with the scene on their own and take any weapons off of Mr. Gentry that needed to be taken off of him.
Was there any testimony to support that?
No, that there's no evidence in record of that occurring because Mr. Chandler's cross-examination was cut short. Also, Ms. Jones made the decision not to testify.
But when you say his testimony was cut short, it was cut short by the trial court not allowing him to testify to this alleged statement that she made? Is
Yes.
that the cut short you're talking about?
Yes, Your Honor.
Well, did the trial court do anything to prohibit him from testifying about, I saw somebody steal a weapon off of the victim?
I don't, because I wasn't trial counsel,
Sure.
I don't know for sure the thought process that Mr. Cate was going through at that point in time, and whether or not, obviously, I don't know his trial strategy and whether or not he had those questions provided. If I had been trial counsel, those would have been questions that I would have had prepared, but that's the best that I can answer your question at this point in time.
Understand.
Sorry, it's a weird position to be in right now. Going forward, so I do believe that with the limited time I have left, it is really, it was a degradation of her constitutional right for the trial court to not allow Mr. Cate to at least set the stage to whether or not this was an excited utterance. This was basically his knees were knocked out with underneath of him before even being able to be given the opportunity to stand, and that in itself was a violation of her right to confront Mr. Chandler. Additionally, the state will argue that this is a self-serving. The he was robbing me is a self-serving statement. I believe that you have to take the idea of a self-serving well, the definition that I found at the Cornell School of Law Legal Information Institute online said that a self-serving statement is in the legal context is a statement or answer to a question that serves no purpose and provides no evidence other than to strengthen a legal argument of one party in a lawsuit. Ms. Jones is a lay person to the highest degree. She does not have legal education nor any secondary education. She does not know of self-defense as a all-out defense to murder. She would not know that and did not know that in 2016. There's no, and thus a reasonable person with her level of education and intellectual ability would not have known that this would have been a self-serving statement, and you have to have known that it would be self-serving in order for it to be defined as such. So I don't believe, and there's no evidence in the record that the state has provided that shows that this statement was in any way self-serving. So I do not believe that the trial court finding that the statement was self-serving was a proper finding, and that it was completely erroneous in their finding, and it definitely violated Ms. Jones's constitutional right. Finally, in the last few minutes, I would like to talk about the trial court's error in the Ferguson motion that trial counsel brought up at the end of the state's proof. As we've kind of noted before, Ms. Tipton was an eyewitness to the incident, as was Mr. Chandler. Ms. Tipton gave an interview to detectives right after, contemporaneously with the incident. And for whatever reason, that interview was never given to defense counsel, and it was lost by the detectives. In the state's response...
Will the record demonstrate to us that there was an actual recording made of Ms. Tipton's statement? Was there an actual recording made?
So my understanding of the record, in reading the record and in speaking with trial counsel, is that he was under the impression, especially given that he had done a motion to compel for that interview, that he had been told that there was the interview, they just couldn't find it, and then it wasn't until trial, the day of trial, that they discussed, or that he was told that this interview was lost. And that, in fact, I believe that the record does show that the detective said he had it, but did not, kind of shrugged his shoulders as to where is it now. When he was asked, where is it now, he said, I just don't know. And I think that this is a really, really important issue, not just because the loss of such evidence is a violation of my client's constitutional right and a violation of Ferguson, and in this case should have been dismissed because of that, but also in allowing the case to not be dismissed under this Ferguson motion allows the detectives, it sets a precedent for MMPD and other police forces in the state that go ahead, lose a really important statement. It's fine, don't worry about it. The negligence that was shown in the losing of the statement cannot be undone. It cannot be misconstrued into something that can just flippantly be let go. I think that this should have been used as a lesson to MMPD to really track and strengthen their chain of custody methods. Thank you.
You're starting to get into your rebuttal time.
Oh, sorry.
That's all right.
Thank you.
General, for the state. Good morning.
Good morning, and may it please the court, Caroline Weldon on behalf of the state. This court should affirm the defendant's conviction because she planned to meet the victim under the pretense of a narcotics transaction and shot and killed him during the course of that event. I will confine my oral arguments to the issues that counsel highlighted during her argument, but if the court has questions about any of the other arguments, please do ask, and I'm happy to address those as well. Beginning with the denial of the motion to suppress, the defendant asked the trial court to suppress two things. the contents of her cell phone and her statement to law enforcement. As the trial court, or excuse me, as you noted, she did not include the claim in her untimely motion for new trial, and thus it is waived. However, should this court choose to reach it, the defendant claims that the data on her cell phone led investigators to connect her to the crime. That argument appears to be based on a fundamental misunderstanding of the sequence of events as it unfolded after police arrived at the scene. Law enforcement learned about the defendant's identity when they searched the victim's cell phone because she was the last person that he communicated with before he was killed. Once officers searched the victim's cell phone, they discovered her cell phone number that they then input into their own law enforcement database and discovered her identity that they then further confirmed by searching that cell phone number in Facebook. At the same time that this was happening, the defendant told her mother what had happened, and her mother reached out to her pastor, Pastor Duke, who was also a police chaplain, who then relayed the defendant's name to his colleagues back at the police station. So this was not a situation where the police were unsure who the defendant was. They knew pretty quickly on who the victim had been in contact with just before he was shot and killed, and at the same time, a police chaplain is saying, hey, we have a name of someone who we believe was involved in the shooting. After she was arrested and after she gave a statement to the police, law enforcement obtained a search warrant for her cell phone and its contents. And in that sworn affidavit, it expressly provided that there were communications between the defendant and the victim just prior to the homicide. Again, the defendant arranged to meet the victim under the pretense of a narcotics transaction so that she could shoot and kill him. For this reason, the trial court properly found that there was a clear nexus between the defendant's cell phone and the crime. If there are no questions about that particular issue, I'd like to turn to Mr. Chandler's hearsay statement. In her brief, the defendant contends that she was entitled to cross-examine her uncle, Mr. Chandler, pursuant to the Confrontation Clause, that the trial court prevented her from laying an appropriate foundation to present his statement, and that the hearsay statement was not self-serving. And just for clarity, the statement is, he robbed me. So that's the statement that we're talking about. There is no evidence whatsoever that the victim attempted to rob the defendant at any moment during their very brief transaction as she sat inside her uncle's van. She cannot.
So what does the surveillance video show in your?
It shows the victim approaching the van where the defendant and her uncle are seated. It seems to show a very brief exchange through a window, and then it appears that the defendant then opens fire. The victim attempts to flee, and she gets out of the van and pursues him and continues to fire.
Does it show anything that resembles the victim robbing the defendant?
Nothing in the still images of the surveillance video suggests that there was any sort of robbery, that he was armed, that there was any sort of struggle. And her uncle testified to note that her uncle testified that after the victim gave her a baggie of pills, that instead of tendering payment to him as he would have expected, she said, "This is what I got for you," and opened fire. So nothing in the record or on the surveillance video or the surveillance video stills indicates in any way that the victim was armed or that he had attempted to rob her or take a piece of jewelry or anything to that effect.
General, I don't mean to sidetrack you, but this claim by the state that the defendant waived the issue of the search for the cell phone, I see that item 6 of her motion for new trial is the court erred by denying the motion to suppress Jones's cell phone. Does that not cover?
Then that would cover it, Your Honor. perhaps I missed that in the amended motion for new trial. I thought that she had waived it, but if she did not,
I mean, it's a motion, I can't see this, September the 2nd, looks like 2022, that was filed, motion for new trial.
then my apologies, Your Honor. If I missed that in her amended motion for new trial, then my apologies.
Well, you're saying amended motion. This is a motion for new trial. Was this the motion that was filed after the delay? This one was filed by Ms. Coleman.
And I'm sorry, what was the date that you were?
September, it's not a big issue. It's just something that, September the 2nd, 2022, it looks like.
Then that must have been after the trial court granted sort of the second chance for motion for new trial. So
It is.
perhaps it was contained in that and not the two prior motions for new trial.
Okay.
So thank you for
It
clarifying
does appear
that.
to be covered in her motion, in the motion that Ms. Coleman filed.
Thank you. My apologies. Then I must have missed that in the third iteration for the motion for new trial. But in any event, waiver notwithstanding, the trial court properly denied that motion to suppress. Turning back to Mr. Chandler's hearsay statement, again, there is no evidence whatsoever that the victim attempted to rob the defendant during their brief exchange through the window of the van. The defendant failed to lay the foundation for an excited utterance. And while she claims that the trial court prevented her from laying that foundation, at the time that she sought to introduce the statement, "He tried to rob me," Mr. Chandler had only testified that the defendant had shot the victim, not that the victim had robbed her. And the defendant cannot shoot someone and then claim that in and of itself is a startling event and then try to offer some sort of self-serving statement to explain why she shot him. And of course, the statement is self-serving. Intuitively, even a layperson would understand that if you've shot someone and you don't want to get in trouble for shooting someone, that you should offer some sort of explanation to perhaps a sympathetic uncle nearby who could then perhaps explain the events in a way that benefits you. So it would seem, by telling her uncle that he had tried to rob her when nothing else other than her statement, or her alleged statement to her uncle suggesting that, that it was self-serving, and that she made the statement for the express purpose of lessening her criminal liability. And again, there's just absolutely no evidence whatsoever that the victim attempted to rob her during their brief exchange. Turning now to the defendant's Ferguson motion. This is not really a Ferguson claim, for it is not about the preservation of evidence, but about evidence that the state never created. The defendant claims that the state lost a recorded interview of a woman who lived in the apartment complex, Miss Bertha Tipton, and she insists that this recorded interview would have proved what she claims, that the victim attempted to rob her, prompting her to shoot him. But she cannot show that this recording exists, and as Detective Coate testified, when he interviewed Miss Tipton, the recording equipment that he was using at the time of that interview had been faulty, and no recording of their conversation existed. Another detective later interviewed Miss Tipton again, and he summarized their telephone conversation, and that was given to the defense. In that summary, Miss Tipton relayed that she heard gunshots, and that when she looked out of her window, she saw someone pointing a gun at another person. She told neither detective that she saw a robbery or anything indicative of a robbery, only that she saw a person being shot.
Did she testify at trial?
She did not. The trial court properly denied the defendant's Ferguson motion for that reason, and this claim is without merit.
And do we have that summary of the phone call? Is that in the record?
I don't believe that the summary itself is in the record. It's just the testimony, as far as I can recall.
It was provided.
Yes, Your Honor. If there are no further questions, I would ask this court to affirm the judgment of the trial court.
Thank you, General.
Thank you.
Judge Holloway, any questions? Thank you, General. You still have your time.
Thank you. Just briefly, speaking about what the general spoke about, first in the what I would call the ill-gotten phone records, I do believe that this motion to suppress, well, obviously we found it in the record, but that it was not properly ruled upon by the trial court, even within the confines of the search warrant is where we really need to look as to what was proposed by the police as to why they needed this cell phone record extracted. And as stated, the search warrant was not given until 2 weeks after the phone was actually extracted. So it was the phone, which was a personal property of Ms. Jones, was extracted without her knowledge, without her waiving of that right, and so therefore should have the search warrant.
What is the proof in the record to support that?
I think it's the timeline. So my understanding of the record is that on the 27th, the cell phone, or the 28th, the cell phone was given and extracted, but the search warrant wasn't gotten until June 14th. Again, I could be mistaken, but that's my understanding of the record that I was able to look at. And then going on to the excited utterance, it is of the utmost importance that a trial court allow latitude, especially in a case like this, especially in a case of first-degree murder, that they allow some latitude for a trial counsel to lay a foundation for the defense to be, for his client's defense to be put forth. And this trial court really narrowed that capabilities of the trial counsel, really narrowing Ms. Jones's capability of creating a defense for herself, which is her constitutional right, and that happened because of that ruling by Judge Smith to not allow him to cross-examine Mr. Chandler on that specific utterance. So we would ask that you take that into account as well. And then finally, about the surveillance video doesn't show inside the car, so any note from the state saying that there's no way that the robbery could have happened, there's no way to know one way or the other because you can't see what happened actually inside of the car, just the outside version of the car. So I would argue that even more so, it would have been really important to allow Mr. Chandler to have that cross-examination questioning. And for those reasons, and for the denial of the Ferguson motion, which again, I think is imperative to proper chain of custody practices going forward, we would ask for you to grant our motion and grant Ms. Jones a new trial. Thank you.
Thank you, Ms. Coleman. Any additional questions, Judge Holloway? Judge Ayers? We're good. Thank you. No.
Thank you.
Thank you both for your arguments in the Jones case. We'll take the matter under advisement, and the record does reflect, Ms. Coleman, that you were appointed on this case. We appreciate your take.